This is case number 24L01159 FY People State of Michigan versus Thomas Rostall.
Deja Dog on behalf of the defendant, Your Honor.
And Mr. Rostall, can you tell us your name?
Thomas Eugene Rostall.
All right, and we're here, sir, for a probable cause conference on one count of carrying a concealed weapon, and that is a felony charge as well, carrying a maximum penalty of 5 years, $2,500 fine, and forfeiture of the weapon. Also, count 2 is possession of a firearm by a prohibited person, and that is a 5-year felony with a $5,000 fine and forfeiture of the weapon as well. And you have a right to have your preliminary examination on those 2 felony charges within 21 days, of your arraignment, which is passed because that's been a year ago. And it looks like you were found or picked up somehow and arraigned back on July 28th. And then again, you weren't in the jail, so you weren't arraigned. So then they did arraign you finally on September 15th. So, but you still have a right to have a preliminary examination on those 2 charges with counsel representing you. So you understand that, sir?
Yes, I need a new counsel, though.
Okay.
I have complete breakdown with the communications with Miss Dial. We just can't communicate at all. She will not take any phone calls from me saying it's office problem. I'd appreciate it if I could get a pro bono attorney that I can talk to at least on the phone, because she says anybody in her office will not talk to anybody on the phone. And that is a rarity with communications between a client and attorney. And she will not discuss the case or some of the problems with the case or any of the evidence that might be available. So I have no confidence in her at all.
Okay, you certainly have a right to speak with your lawyer. That's for sure. What's going on there?
He doesn't think so. So, that's.
Well, let me ask her what's going on from her perspective. What's going on, Ms. Dye?
Judge, that is inaccurate. I did indicate that we do not speak on recorded lines, which jail calls are. However, I do schedule video visits. I've had 2 separate. If you would let me speak, I'll let you speak without talking over you. So please stop talking while I'm speaking. I scheduled 2 video visits with him through the Macomb County Jail system, which is IC Solutions, both of which were at least 30 minutes long. I have been communicating with him. However, I will not discuss privileged information over a recorded line. That is accurate.
No, that's not going to work.
Further,
that's not going to work.
Again, as you can see that he's consistently speaking over me, I will leave it within the court's discretion.
I don't want anything to do with you.
Okay, sir. You do understand you can't choose your lawyer, right? Do you understand that?
I'm saying that she won't communicate with me. The Zoom that she's indicating were all interrupted on her end, according to the deputies here. I couldn't communicate at all on those Zooms. She will not take a phone call, even though I pay for it, saying that it's office policy, and no other lawyers in any other the county that I've had problems with, they talk on telephones all the time. And she just doesn't want to communicate. She doesn't want to talk about the possibilities of the case or anything. And so all she wants to do is process me without any communications. Our breakdown on is a complete attorney-client breakdown, and that's it.
Okay, sir. Now, I'm assuming what she's trying to say is there's a recorded line, and she does not want to breach any type of attorney-client privilege by doing so. So what if she would listen to me? Oh, my goodness. I just know you're not about to talk over me.
Yes, ma'am.
So what if she scheduled a visit to you so that she could hand you the discovery and talk to you? Because you're in Macomb County. You're not in Ann Arbor.
You can do
So,
that, but I just can't. She doesn't appear to be interested in my case worth it.
well, sir, listen. That's not exactly accurate from what I'm hearing. And
Yeah.
each one of our lawyers go through rigorous training, and they have to meet prerequisites to even be able to represent you. So she's not just going to try to push you through the system without having any kind of conversation with you and not being totally interested in your case. And matter of fact, Miss Dial appears in various different courts. This is the first time I've ever heard anything like that about her.
Uh-huh.
So I'm saying that rather than try to take her off the case, give you a new lawyer, I'm going to ask her to visit you when time permits in her schedule at the Macomb County Jail, where you can have some type of face to face conversation, not on a Zoom or an iPad, and not where it gets cut off. And she can bring whatever discovery that you haven't seen so that you can have a copy of it and you all can discuss the case. Now, lawyers are not here to tell you what you want to hear. They're here to give you an assessment of what they think you should do because they're trained and they understand that. So you got to listen. It's in your best interest to listen at some point and not be so hostile towards her.
I'm not hostile, Your Honor.
Okay.
Your Honor, I've been through a lot of court system, and she won't even
Okay.
accept a telephone call. All this about recorded lines, it doesn't exist in other areas, and it's just a maneuver that she doesn't want to hear.
Let me tell you
Take
what
a
I
phone
know.
call.
Let me tell you what I know. They record every telephone call from the Oakland County jail. I don't know what they do in Macomb County, but I got a sneaking suspicion they record everything too. And that's because
So
they don't
how
want
can that
anybody,
be?
excuse me, they don't want anybody threatening witnesses. They don't want anybody sending people over there to threaten victims. They want to make sure that everything remains on the up and up while cases are pending. And they certainly don't want anybody conducting criminal activity from the jail. So they listen in on every single phone call. So you're wrong. That is true that those lines are recorded. Now, if she has a face to face visit, they don't record those. So that should be the thing that should happen. So she can speak freely to you and you can speak freely back to her. And you've already made up your mind that this is all a lie and it's not accurate. I know what's going on. I've been doing this for 40 years. Okay. So I do understand how the jails work.
All right. Okay.
So you got to keep an open mind. We're trying to get you some help, Mr. Rosto, which you're entitled to have on this case, which you already know. And so you guys got to work together on this. I don't do the appointments. This comes from another source whatsoever that's outside of this court and outside of my city. It comes from a county. And they don't take too kindly to removal of lawyers for incidental reasons because they don't have a lot of people to go around. So you got to try to make this work and if something's going to happen where she has to be removed or anybody has to be removed, it's got to be something significant, not the fact that she refused to talk to you because the line is taped. So, Ms. Dial, I'm going to adjourn this probable cause conference, give you an opportunity to figure out, how your schedule is so you can get over there and take him whatever. And listen, Mr. Rosto, I'm not kidding. You need to be civil to her.
I was civil, Your Honor.
Well, then that's good.
I need to have conversations back and forth that had meaningful.
Yes, you are right. You are absolutely right, sir. And that's why I'm going to send her over there. Okay? You are right on that. So, Ms. Down, how many weeks you need? 2?
Yes, please.
All right, we're going to adjourn this matter 2 weeks for you to do a jail visit.
Can I ask you one question, Your Honor?
Yes, sir.
Is that going to include body cam footage? Is it going to include a dash cam footage? Is it going to include communications between the two? You have an outrageous Fourth Amendment search and
Okay,
seizure.
Sir, you're not a lawyer. So don't tell me about the Fourth Amendment and constitutional rights. We all know about that. Your lawyer knows, I know, the prosecutors know. They're not going to withhold any information. And if there is, my prosecutor here who's standing at the podium is very well known for getting discovery out quickly to the defense lawyers. And it's an electronic file, which means there's no disk even to put in anything. It has to be downloaded. So she would have to bring her computer. And Ms. Dial, if you need an order, because that's the way they do it in Oakland County, so I'm assuming it will work in Macomb County. If you need an order to allow you to bring your computer into the Macomb County Jail to review audio, video discovery with your client, I will write such an order out to allow you to bring in the computer with the downloaded videos and whatever else that's been provided. Mr. Shockley, what did you provide?
I provided written discovery on September 25th, as well as AV discovery, which consists of 12 videos.
So there's 12 videos here, sir, that she has. And Ms. Dial, did you receive those yet?
Yes, Your Honor.
So just make sure they're downloaded into your traveling laptop so that he can view it. And then you can go from there. So, yes, Mr.
I
Shockley.
will also say, since the day this case came up on our docket and Ms. Dial was appointed to this matter, she's been in extensive contact with me about trying to resolve this as fast and as easy as possible. As far as a misdemeanor, reducing it from a felony. So that process is already in the works. She's working very hard in the defense behalf.
Okay, sir. Well, you heard the prosecutor say she's working hard, trying to resolve it too, trying to get you a misdemeanor rather than a felony, which is part of what her job is too, while she's reviewing the discovery. Okay.
I may have panicked here a little bit. I'm sorry. I just worried about this, the way it happened.
It's okay, sir.
I apologize.
You just got to remain calm. We understand you're incarcerated. We understand this is your life and you're entitled to have some feelings about your case. But
I turned myself in on all this to stop this crack run that Judge Cedric Simpson in Washtenaw County appreciated that. I'm sorry.
Well, that's okay, sir. You know, apology is accepted. Your lawyer will accept your apology. She's used to dealing with folks that can be difficult. And that still doesn't mean she's not going to give you the best defense you're entitled to. And it sounds like she's been working and you just didn't know. Okay. And congratulations on trying to turn yourself in so you could stop whatever drug issue that you have and get some help for that. And hopefully that is going to be the long range goal. It's never too late. You gotta know that. It's never too late, Mr. Rostow, to make a change. I don't care how old you are. You can make a change. You can get off a controlled substance. All you got to do is have the mindset for it and have the heart for it.
I do.
Nothing can stop you. Okay. So we're going to give you your next date and we will arrange another video conference with you for that date. And what's the date?
Court's available October 22nd at 9 a.m.
October 22nd, Ms. Dial, at 9. Is that good?
Yes, that works, Your Honor. Thank you.
Okay. 9 a.m. on October 22nd. So in the interim, she'll have the jail visit. And I guess I need to write this order out now.
Yes, please, Your Honor. Thank you.
And how you gonna get it? You need us to just mail it to me?
Yes, if it could be mailed, that would be appreciated.
I can't vouch for the post office, but we'll try to get it to you. Yes, ma'am. That's what we'll do.
If I need to I'm not gonna be back there.
We're going to review discovery and videos. I'm going to prepare order. His bond is going to be continued. And we will need him again for the next date. All right. So the next date is an adjourned probable cause conference date. And we will see you then, Mr. Rostow. Okay.
Thank you, Your Honor.
You're welcome, sir. Okay. And we'll do this order for you, Miss Dyer.
Thank you, Your
Right
Honor.
now. All right. So this is it. Okay, sir. I can let you out so that they can take you back wherever you need to be, and you're gonna be all set, okay?
Thank you, Your Honor, very much. I'm
All
sorry.
right. You're okay.
Sorry.
You're okay. All right. Bye-bye now. Okay, this is case number 24S00705 FY, People of the State of Michigan versus Deshaun Stewart. And he also has another case that I don't have. Or do I? Yes, I do. It's case number 24S00579 and 24S00705. And they're both people of the State of Michigan versus Deshaun Stewart.
Chuck, on behalf of the people.
Mhm.
And Mayor Ruby on behalf of Stewart. Good morning.
Good morning. And where is Mr. Stewart, if you know?
I do not know, Your Honor. We were here last week and I stood here with Mr. Stewart in front of Your Honor, and I had a conversation with Mr. Stewart, who was here for a violation of probation, and Mr. Stewart told me that, and as Your Honor can see, there were a number of factors that were listed for his violation. Mr. Stewart told me very confidently that he had proof that he had
Mhm.
completed several of the terms of his probation. Probably not all of them, but several of them. But he indicated that a lot of them were in his phone, and his phone was at 1%, and then he can have more time to get me the documentation. And so I stood here and begged Your Honor.
Yeah, I remember. You sure did.
And I asked for another date,
And I gave it to you.
very graciously gave us another date. And then in the meantime, I also continued to beg Mr. Stewart for that information. If he could send it to me by email or by text throughout the week. And I did communicate with him, and he indicated he would give it to me, and he did not. But then I hoped that he would bring it with him today, and he is not here.
And the matter was scheduled for 9 p.m. It's now 10:30
Yeah.
a.m. The defendants felt they cleared. Therefore, the people would very graciously request that you issue a vessel.
And I very graciously will grant that request. Well, he just pulled the wool over your eyes.
He sure did.
Sometimes it happens.
I have to say, he was very pleasant and he was convincing. And I thought, well, the most I can do is try. And I did try, and that's it.
All I can do.
I'm just going to make a note. He did not send any updated info to you
He did.
that way.
This recommendation of everybody's in jail. In light of that, people are asking for a sustained.
All right. So they're both larceny, $200 or more, but less than $1,000. And there looks like there's at least 1, 2, 3, 4 allegations here where it looks like he really didn't do anything. He didn't report. He didn't go screen. He didn't provide proof of mental health assessment. He didn't register for the life skills class or an economic crime class. So, yeah, and last time I gave him 3 days in jail. No, actually 3 days in a work program in lieu of jail, and I kept his item.
Yeah.
Ugh.
That was part of the reason why I really wanted to get an adjournment, because he was on this HIDA status and he's a young person.
Okay. So on the one count under case number 24S00705FY, I'm going to make the bond, because this is also a larceny, $200 or more, but less than $1,000. Make the bond $3,500 cash or surety. And then on the other one, I'm going to make it $5,000 cash or surety. And I make a note, do not change the bond.
Thank you.
Okay, well, thank you for your efforts.
I tried to thank you.
Yes, you
That's all
did.
I am.
Okay. This is case number 23H00742SM, People State of Michigan versus Sky Reeds.
Robert Sharp, on behalf of people.
Morning, Your Honor. Please support hearing on behalf, Honey Girl appearing on behalf of Mr. Sky Reeds for the purpose of today's probation violation. Judge. Just speak your full name for the record.
Sky Paul Reach.
Okay, Mr. Reeds, you are here for a violation hearing. You're on probation for, looks like malicious use of a telecommunications device. Looks like you were here June the 16th. So that's on something else. Let's see. Because it looks like we got on September 9th another updated.
It was for mental health exam. I couldn't afford it. And I didn't know, you referred me to Easter seals. I didn't know about them.
All right. Looks like before we had adjourned this without any adjudication, and that was for Easter Stills evaluation. And I had noted that was back in June that if we got a report from the case management coordinator, Easter Stills, the PO might withdraw the violation if needed. But since then, we've gotten a violation on September the 9th of 2025. We didn't even deal with the April 21st violation. And that one was failing to obtain the psychiatric evaluation and failure to make payments. This new one from September 9th is failure to report as directed to probation and failure to test as directed. And of course, you have a right to have a full violation hearing on all those allegations from each one of those petitions. And you have a right to have your lawyer represent you at a full hearing if you like. And at that hearing, of course, the burden to prove this matter and the violations would be on the prosecutor. They have to prove it by the preponderance of the evidence, meaning the greater weight of the evidence. More likely than not, tipping that scale, if it's balanced, tip it a little bit, 51 to 49%, to convince me that you're in violation in the matter being claimed. So if we have a hearing and we find you guilty, or if you choose to waive that hearing to plead guilty, that's when the penalty phase comes into play. And this is malicious use of telecommunications devices. It looks like it was reduced from a 1-year stalking misdemeanor. Is that right? Okay. And so that malicious use is a 6-month misdemeanor. Okay, so that could potentially be the maximum penalty. So you understand all that, sir? Okay. How would you like to proceed on this one, Ms. Gurula?
Thank you, Judge. I've had the opportunity to speak to my client regarding the allegations set forth in the probation violation summary report. It's my understanding that the violation number 2 was adjourned twice for him to obtain the information, but then the VOP was canceled based upon this report. So it was my understanding that
they canceled the other one? Okay.
In regards to the allegations of my client failing to report to probation as directed and failing to test as directed, he's prepared to put an entry of guilty to those allegations. And we're prepared to move forward with an explanation and sentencing.
All right. So is that right, sir?
Sure.
So we're talking to the September the 8th September the 9th allegations of failing to report to probation and failing to test as directed. So anybody forced or threatened to make you give up your right to have that hearing? Anybody promise anything to you? And are you waiving that right freely, voluntarily after talking to your lawyer? So is it true that you failed to report to probation as directed? They say you missed some appointments August the 12th and then did not report for the rescheduled appointment on September 9th. And also they indicate here that you did not test as directed. You did not go on August 20th, 2025. You attempted to go late on the 21st, but couldn't produce a specimen and you didn't come back at least till August 25th. Is that true?
Yes.
Okay. Well, a sufficient basis here for the plea. And I'll find that it is sufficient and that the plea is freely, understandably, voluntarily, accurately, normally made. Okay. So what do you want to say? It says here, let me see. Well, what do you want to say, Ms. Grillo?
In regards to the reporting issue on on September 9th, my client reported on August 15th or August 12th, rather, he left his work site and drove. It took him 55 minutes to get here. He left early in order to get here. Traffic on 696 prevented him from arriving timely. He was 12 minutes late when he arrived. They rescheduled it. He wrote in his calendar book 9/12. That was his understanding to be here on 9/12, not 9/9. He wrote the wrong date down. So he apologizes to the court. In regards to the failed testing, I know the court is well aware of my client's health issues and that he has some surgical needs in his lower back, which causes severe inflammation. As a result of that severe inflammation, sometimes he's unable to use the restroom. Due to that medical condition, he recently was prescribed a new medication by the name of Melexicon, and that is an extremely strong anti-inflammatory, and it's been a night and day result from it. When he's gone to testing centers and he's struggled, they've noticed that. But when he's gone recently, they've actually commented on how much he's able to produce because now he's able to use it.
Also, it enables him to produce even more.
Yes, he can use the restroom because what was happening is he'd be, for lack of a better term, backed up all day. And then he'd be able to go throughout the night and sometimes he'd go at 3 a.m. and be able to produce.
This just normal, like whether or not he's trying to test, just go normally at home?
No, he struggled with that as well. And so he'd be on a work site for a long period of time without being able to use the restroom. Wow. And so this medication has reduced the swelling, which has reduced the issue that was causing his bladder to not be able to use the restroom. And so now he says there's been no issues whatsoever since he's been taking this medication. He's quite happy with the results. So those are his explanations regarding those violations, Judge. He does work, he's a union member and he does work underground. He's working with the crew, and as a result of having to leave in some of those issues in order to do the testing and things along those lines, they've taken him off any and all overtime work. And so now he's limited. He's already financially strapped because the court is well aware of it. It's also going through Chapter 13. The fines and costs that are owing at the 732. When he met with his probation officer, Ms. Moore, she made some recommendations for some additional community service, and perhaps the court would be inclined to give him additional community service because of his financial difficulties. He wants to complete probation.
I don't have a problem giving up community service, but you got to get it done, Mr. Reed.
It's absolutely true.
My client also indicates that he's prepared to do the community service when he's done it previously because he really enjoyed the services that were provided by that entity.
Where was that?
St. Jude's, in, off of Hall Road, I did like, 17 extra hours.
Yeah, as long as that's a verifiable 501c3.
And Judge, my client had been testing previously in Shelby Township, which is where he lives.
Mhm.
But he works off of Aiken Shaner near Warren. And so he found a testing facility within 4 miles of his shop. And so there should not be any issues with that because that's the one in Warren is actually open until 8 p.m. So when he's finished with the site work, he can go right there. There should be no further violations. Judge, we just ask you to take that into consideration.
Shockley, anything from you?
No, Your Honor.
What do you want to say, Ms. Reesner?
Sorry.
You were trying to say something earlier. What do you want to say?
Yeah. So I have a mass on my spine that they're going to remove. And, I have to have $700 for it for it to be done. Because it's causing major inflammation. That's what I've been telling you all. I sleep some hours and relax and have no movement. And it's like I'll go like 3 times one day. Strong air out. Then during the day, I try to drink more and more. And all it does, a couple times it started to make me sick from too much water. And I spoke with her about it the whole time, you know, how it was going and stuff. And I told her I'm starting to have problems urinating stuff and, you know, like nothing to hide.
Well, let's see. Let's hope what your lawyer said is true. I'm willing to give you a chance on this community service. They're recommending 8 additional hours of community service, which I'll do, for missing the test. Obviously, they want you to test on time and report to probation. And I don't mind adding community service in lieu of fines and costs if you can't pay. Some people like to use a combination, pay some, because it's a lot of hours. I don't know what you're doing over there, but if it's bothering your back, you might want to do some payments and some community service.
Yeah, well, I'm trying to sell a motorcycle I have that I'll keep through the thing instead of. It's a little too big to think, but that's what I'm trying to do. That should cost. Just having had a couple of people call and they just give it a run around for sure.
All right, so we'll continue the probation with 8 additional, with all terms and conditions, let's say.
Judge, if my client were to decide to work at community service in lieu of the fines, it costs $732. How many hours is that? Like 74 hours?
Well, let's see. Yeah, 10, yes, 10. So it's probably about 72 or 3. You said 732? 20 O's. Yeah, that's 73.2 hours, so like 74. Mm-hmm. All right, so continue everything you're supposed to do with 8 additional hours of community service for the missed test. Please test on time and report to probation as ordered. And we will add another provision for community service in lieu of fines and costs. If you'd like to exercise that, and you get $10 an hour for each additional hour that you do. All right, so you're all set. Mm-hmm. Okay, this is case number 25S 00550 SM, State of Michigan versus Dwayne Deal.
Robert Sharp on behalf of the people. Good morning, Your Honor. Joe Freeman on behalf of Mr. Deal, standing to my right.
All right, Mr. Deal, good morning. Mr. Freeman, good morning. We're here for a pretrial on intentional dissemination of sexually explicit materials. This is a 93-day misdemeanor with a $500 fine. How would you like to proceed?
Your Honor, at the last hearing, we requested an adjournment so I could subpoena his mobile records from T-Mobile. I have yet to receive those records yet.
Yeah, it says here adjourned for you to look into the chain of custody and get phone records and look at the authenticity of photos.
That's correct, Your Honor. My client is not willing to move forward at this point without a forensic investigation done, either by an independent interviewer or one through the state to look at the videos.
Wait. What video? The ones that they have of him allegedly viewing some kind of
That's correct.
explicit material.
That's correct.
Okay, and so you want somebody to go through and look at that and make sure it's the real deal?
That's essentially it, yes.
I don't got the right person here, Miss Grillo. Hey, do you provide an expert for something like that? I don't even know.
It's a matter of finding the
You
right.
gotta find it. I don't know, Mr. Shockley. I'm sure who's this case from? The Southfield Police or who? Yep, Southfield. I'm sure Southfield Police have somebody that does it. If you know, if you don't mind them doing it.
I suspect my client would want an independent investigator and forensic expert.
Wow.
Not one from the.
She can get one appointed for you, but you're gonna have to research it and let her know.
Probably about a 45-day adjournment, just so we can figure that out.
All right. Once you determine the authenticity, one way or the other, then where are we going with it?
Well,
Let's just say it comes back as this is authenticated, whatever it is. I haven't seen it. I don't know what you're talking about.
I suspect that if we get to that point, in case a motion for dismissal is not granted at that point, my client would eventually, at the end of the road, be sending for a trial.
Okay.
Is that correct, Mr. Deal?
So he's probably going to want a trial no matter how authentic they are.
Yes.
Okay.
And, Your Honor, so the court's aware that there's a concurrent felony matter that's currently working its way through the circuit court that involves the same victim.
What's the charge on that?
Larceny, $20,000 or more. Yeah,
Oh, y'all can't package anything up?
Well, that doesn't resolve it down to any stage. He's just had a new attorney appointed in that.
Ah, okay.
So
Mr. Streamer, were you aware of that?
I am aware of that case. I didn't know the progress on that.
Do you know who? Is it out of this jurisdiction?
I believe it's out of Southfield.
Let me look up his name. See what I got.
Larceny, $20,000 or more. Patrick Goodnock. Donna Gagnon.
Yeah.
They're just out of the Southfield Police Department. No. Yeah.
Patrick. Okay.
Mr. Valley is for. She was in.
I think the preliminary exam actually came before you or something else that comes to admit.
Well, I'm about to check it out right now and see what's the status of it since it's here.
Don't expect a global resolution to happen.
Okay. DIWA.
We need that. Be something. Commercially independent. So.
I don't see anything yet. Did you see a case?
Oh no, it's bound over to the Sixth Circuit already.
The other one?
Yeah, it looks like it came to a preliminary exam before you on November 4th.
So it'd be closed. 2024. Okay.
It's still open because multiple attorneys have been.
Well, it'd be closed for us.
Yeah, it's close. Yeah.
Yep, and it's my name on this. Let's see what it is. Larceny 20,000 or more?
Yeah.
It was disposed of last year, November 4th.
It was bound over in litigation.
Okay. Patrick Gagniak.
Sounds like he's no longer the attorney on it, though. So then, you said Miss Miller. Those are notes for her first name.
Yeah, that's when he accused himself too.
Miss Miller.
He accused himself of abandoning court life.
They recused themselves. That can't be the right word.
They asked to be released.
Yeah. Yeah. They just want to withdraw.
Okay.
Judge Valentine?
Yeah.
Okay. Well, no global resolution, then we'll just deal with this one separately. So we'll adjourn this 45 days. And then you're gonna want let's see. You want a final pre-trial on this or no? You just want a trial date?
I think my client would like to set a final pre-trial before
Okay.
we need time to get expert. They just didn't actually say anything.
Now, if you don't want that, let me know because I don't need to adjourn that.
We get a misunderstanding on laws and how they're written and spoken.
Okay, well, what's the question? What you confused about?
This time I was in court. We talked about this officer. Authenticity. Phone.
We talked about what?
Statistic of the phone.
Okay.
The my understanding is here. After the first adjournment of the court, in addition to
Yes, it was.
the nothing happened. Why didn't
Now, I can't answer that. I'm not your lawyer. You need to be asking him.
what happened to for the record, what happened between those 4 weeks?
Okay, I don't know. What did you do, Mr. Sheena?
Your Honor, I filed a subpoena with his mobile company to get the actual mobile records.
And you know, they take a little bit, don't they?
Well, I don't see where he did that and
Well, how you gonna see it?
because he asked me to get the information from me on it.
But how would you know if he subpoenaed it?
Would be keeping informed these type of things. I had information.
I don't know what he would have told you, but I do know he got a number of clients and he may or may not have told you, yes, I actually subpoenaed them. And he probably won't say that until he gets the records. You got what record?
The phone.
You got what?
My phone record.
Okay, well, if you have a phone record, why do you need them subpoenaed then? Because, you know, the phone company has data that you don't have.
That's see then that leave. I have what he asked me for.
Well, okay, but that's one part of it. You got what? You have
You provided me with a phone bill.
a bill.
Yeah, the record, the phone number was changed.
Okay, but if you're looking for who called who, what phone calls went out, what phone calls came in, what towers it bounced off of, that kind of thing, you wouldn't have that.
It's the record. I just want to know what record, what kind of record you for me, because I discussed that the phone was in someone else's possession. And
Well, they would know that maybe by tracing where the towers were hitting, where calls were made, where it was pinging off of, and where you were at the same time.
then I had a record where,
Sir, I would just advise you that anything you say can and will be used against you.
okay,
Please.
where
We can talk about this after court. So
where the phone number was given from the date that I was last contacted by this guy, pertaining to those text messages.
Okay, well, that's what he's trying to do. He probably asked for all of that. I don't know what the subpoena said, but
sir, I can provide you with subpoena if you'd like.
And also a discovery package, everything, discovery package.
what discovery did you get? No, I'm asking.
Your Honor, there's videos that can't be sent from the prosecution that I believe my client has already seen and we've discussed, but in order for him to view those, we get most of the discovery that I believe my client would want to see.
Okay.
Text messages, but not the actual videos, because they have a new policy where they can't send those videos.
So just to make the record as clear as possible, the discovery rule dictates that I give brother counsel a opportunity to inspect the tangible evidence. I don't actually have to turn it over to him as incentive. These videos are extremely pornographic and explicit. So me and brother counsel actually met one day while I was at Waterford District Court, and we reviewed the videos together.
Well, how's he gonna see him?
That was court order that I was supposed to be.
Okay, well,
He has a right to see him too. You want
an
him?
attorney can set up a time to come to the office.
Yeah, I was gonna say you want to bring him to their office and let him see him too.
That's what the court rule dictates.
That was supposed to be 4 weeks ago. He was supposed to do that 4 weeks ago.
Okay, well, what if they do it now? Will you be happy? We want to make you happy.
No, I'm not being happy, it's about being just,
It's about what?
about being just, true and just.
Okay.
And last year,
I don't know what you mean by true and just because the information has been turned over to the defense. So where's the lack of true and just there?
when it was discussed that I be present during the time of examination of the evidence, of the videos, or the.
Okay, sir. We will make sure that okay. Okay. I will write it out in an order. I'm sure I did not write that out in an order before. Do you need me to write it out in an order? I will write it out in order. Therefore, if it doesn't happen, somebody will be in contempt of court. All right. So next problem. What's the next one?
I think we have a plan set forward that will satisfy both myself and my client moving forward. With an independent forensic expert, is that correct, Mr. Deal?
Chain custody, that would both the sister, chain custody.
I'm sure they will look at where the videos came from and
No, actually, what I was asking. That the chain custody is ordered.
Sir, nobody orders a chain of custody. It is what it is. So if you're trying to say it's not the same video and it wasn't in a chain, because those are questions that would be asked of some witness who had the video.
Where my concern is, Your Honor, I was never allowed to be a detective, so after the charges were made.
Okay.
Talking to
What's that got to do with chain of custody, though?
never had an opportunity to see what the piece of stand from.
Okay, sir, but have you ever heard of a defense? Well, we haven't even gotten anywhere yet. How do you know it's not working? Okay, well, I don't know what to tell you, sir.
Your Honor,
Right now, I'm writing out an order that's going to allow you to be present with Mr. Streaman at the prosecutor's office to view the audio, video discovery. No, that's not how this works. Okay, chain of custody is a concept. Okay? So we don't have to have an expert at this point look at the video with you. You just said you want to see the video, right?
Chain custody is what it is.
Chain of custody means wherever it was procured by somebody that was from the police. Then it went through somebody else to the police. And then maybe they put it in evidence. Yeah, but those are questions for trial. Those are that you don't go. There's no proof of chain of custody just to watch it.
Procedures you follow.
Sir, you know what? You got to let your lawyer be the lawyer. I'm not going to sit up here and try to answer every question that you have on this. That's what he's for. That's what he's here for.
You said, talked about the chain of custody. What my understanding was, it was where the cookies came from, who sent up the receipt.
sorry, and she's saying that's what will come out in trial if we get to that.
No, we talked about chain of custody.
Well, okay, I don't know what your definition of chain of custody is, because chain of custody is usually a term that's used to show where evidence was, how evidence was handled,
Right.
not the original person who had it. It's once the police get involved, they got it, and what did they do with it? Is this the same thing that they had when they first started? Did it get altered? Where'd they lock it up? How did they safeguard it? That's what we mean by chain of custody. You're talking about who the witness was that had it and things like that. That's not chain of custody. I can't grant it. It's not a concept for me to grant. It's something to be proven. No. Listen, it's a concept. It's to be proven. The prosecution has to prove that, yes, this is what it is, and it was the correct chain of custody. They have to show that. They have to show that, and that's part of, they handle the evidence. Their witnesses, the police department, they handle this evidence correctly. And this is what they did with it when they got it. So they got it from person A or website, whatever. This is what they did with it. Did they alter it in any kind of way? They have to show that this is credible stuff.
What's the chain of custody?
Yes.
At what point is that?
At a trial or a hearing. It's nothing for me to order. I can't order that. All I can order. Okay. Okay, because you can't order that. It's something to be proven at a hearing. So no, you can go and watch the video, but chain of quote custody is something that has to be proven down the road. And that's something that your lawyer can ask questions about. If he sees anything that looks suspicious in it, he can ask questions of the people who handle the evidence as to what they did with it and how they handled it. And that's what you said you wanted your expert for, is to look at the video, see if it had been tampered with in any kind of way. I don't know if he can say where it came from, but
That's what the T-Mobile records is. Okay.
Sir, this is appropriate conversation between you and your lawyer, not me, you, your lawyer, the prosecutor, and everybody sitting here. This is your work product. Do you really want to discuss your defense in front of the prosecutor? Okay, well, you need to go talk to your lawyer. I was just trying to tell you. I'm going to write out this order. Yeah, to Jessica so she can sign off, stamp it, say it was served in court today. What was that?
There's section, not the title.
Anybody else got any Big Ben chimes? Silence your phones. All right.
Thank you, Your Honor.
You're welcome. That's going to conclude this matter. Mr. Shafi, get his copy too. Okay. This is case number 24S00705FY and 24S00579FY. Oh, people of the state of Michigan versus Deshaun Stewart in both matters.
Representing the American people.
You on behalf of Mr. Stewart. Please state your name, sir.
Okay, Mr. Stewart. Well, today is the date scheduled for a probation violation hearing on both these counts of larceny, $200 or more, but less than $1,000. So for each one of these cases, that's the maximum penalty on this. Could be up to 1 year in the county jail. And you do have a right to have your lawyer represent you at a probation violation hearing. And at that hearing, the burden of proving the violation is on the prosecutor, who would have to prove it by the preponderance of the evidence, meaning the greater weight of the evidence has to convince the court that you are in violation in the manner being claimed. So if we have a hearing and we find you guilty, or if you waive the hearing to plead guilty, That's when the penalties come into play. So you understand that.
Yes, sir.
All right. So let's see. The allegations here are as of August 13th, 2025, failing to report to probation as directed, failing to screen, that's alcohol and drug screens as directed, failing to provide proof of mental health assessment, failing to register for life skills segment D in an economic crime class. And of course, you are on HIDA, which is the Homes Youth Training Act, which means that you weren't supposed to have a record if you just had successfully completed everything. So now you are up to be taken off that status, and possibly this matter could be, both matters could be placed on your record at this time too, as well as subjecting you to additional jail time. So you understand that? Okay. How would he like to proceed? Since we didn't do anything, we had adjourned it last time because he says that he had all this proof that he had done some things.
Your Honor, I had opportunity to speak to Mr. Stewart on more than one occasion, and that is correct. I did ask for an adjournment for Mr. Stewart to bring in some documentation. I will indicate he was forthcoming with me. He indicated that he did not complete all of the terms of.
Well, then why don't we get to that originally?
Well,
why are we adjourning it just to bring in nothing?
I did want to indicate to the court, the first time we were here, he never indicated to me that he had completed everything. That's not what he was going to.
Well, yeah.
And that
You said some things.
some
So what some things did he bring in?
what he brought to me today was one of the things he was ordered to do was a mental health assessment. How old are you, youngin? He just turned 20. Instead of a mental health assessment, he has gotten himself into actual mental health therapy, and he has brought a letter from the therapist, Brian Cook, which I would like to provide to the court.
And did he provide that downstairs to the probation department?
He did provide it to Ms. Fisher. He indicates to me that Ms. Fisher did not take him in the back and speak with him, that she did not look at his documentation and just told him to come back upstairs. So I would like to provide that to the court. He did also draft a letter to the court, and I'd like to provide the letter to the court. I did show both of these documents to the prosecutor, and the prosecutor told me I can provide whatever I would like to the court. So I just wanted to approach the court. These are the two things he has. I had to work what I had.
I don't understand why the probation officer didn't look at the letter.
I mean, am I correct, sir, that she did not look at it, or did she look at it? You can tell me. I wasn't there in the meeting.
She just like on me, so I had to sort took it on my hand, like flat through the paper, barely on down, barely with that skin through it. So you go back upstairs.
I mean, it has contact information, a phone number, an email.
Okay.
I don't. But I will say this. I mean, I guess in all fairness to Ms. Fisher, even if he is in mental health counseling, which I think is good, that still doesn't negate the fact that he hasn't done it, all the other things. So perhaps that's what Ms. Fisher was thinking. I can't speak for her, but being it may, I mean, he is going to plead guilty today because I explained to him that he still hasn't paid his costs and fines. He still hasn't completed the community service. He still hasn't done his work program. He understands that. He completely understands that. And he knows that he has not just failed to complete his probation. He's not just failed the sport. He's failed himself. He understands that. He's disappointed in himself because he had the opportunity.
I don't know why.
To do IDA.
That was his choice.
And he understands that he's 20 years old, he's a student at Wayne State, and he's failed himself. I'm disappointed, he's disappointed, everybody here is disappointed. I don't know what else to say.
What do you want to say? You don't have to lean in that.
You don't have to. It'll pick up as long as you speak up, like I am.
I just wanted to apologize to everyone, even including you, the prosecutor as well, because of the chance that he gave me. That was
Okay. Well, why are we at the point of having to have an apology? Why can't we just get done what we're supposed to get done when we're supposed to get it done when the opportunity was given to you? You don't take this stuff seriously? You want a record? Well, you're about to get one. I don't understand it at all. It's that's weird way of thinking. If you ask me, you walk out of here and just don't do nothing. Then come back and apologize. Still haven't really done anything. What is going on that you would just totally ignore a court order and then expect what? Nothing happens? I'm trying to get in touch with the younger generation, but quite frankly, I just don't understand y'all. You people don't take too much accountability for much. You like everything's supposed to happen for you. You're supposed to just have the money, have the biggest, best job, have the designer clothes. Don't have to put forth no effort for nothing. That's the way most of y'all think. I've been watching this. I don't understand it. I don't know what went wrong because that's not the way I was raised. Granted, I'm light years older, but what happened to parents? They just start giving y'all stuff and just letting y'all do what you want to do. So you figure when you get to an authority figure, hey, so what if it's the law? I don't have to follow that. Okay, so I got arrested. So what? All right. Well, judge told me to do something. I don't have to do that either. Or if I do it, I do it when I'm ready. What's the what method of thinking here? I don't get it. Then you come here and talk about apology. What do you apologize for what? The sheer gall of just not doing what you're supposed to do. But we took this plea August of last year. It's a year ago. You were on probation for only 1 year. You had a whole year to get this stuff done. This was reduced from do you understand this? Felonies. No, you don't get it. Felonies. You could be sitting in Jackson prison right now, or Kinchlow, Kinross, something up in the UP, Ionia, wherever. You could be sitting in one of those prisons for this activity, 2 counts of it. But what happens? No, prosecutors like, oh, young man, seems nice. Let me just reduce the felony to a misdemeanor. Oh, and let me sweeten the deal. Sure. All I gotta do is get something done. And then you just take the kindness for weakness and don't do nothing. I don't get it. Like, you're entitled for this? You were supposed to get this? No, you should have just gone up to circuit court on the felonies. That's what should have happened because you know what? Some people, this is an old person's phrase from the Black community. Some people don't believe fat meat is greasy. Okay? You don't believe it. You from the show me state. Show me. You get opportunity, you throw it away. You're supposed to be grateful. Oh my goodness. Oh geez, I get out of this with a misdemeanor that I'm not gonna have a record. Oh, I'm gonna go straighten up and fly right. I'm gonna make sure I do everything right that I can. That's what you're supposed to be thinking, and you didn't do it. I don't get it. I just don't understand. So all the things I ordered weren't done. Then not even reporting properly. I mean, that's the simplest thing. That's free. And that was the first allegation in February of 2025 and not registering for drug screens. And what did I do on the first violation? Oh, no, 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 no. What did I do? Did I put you in jail then? You missed the opportunity. Maybe I should have done that then. It still kept you hider. Maybe going back there with the folks that's back there in the jail would have been a lasting impression for you to straighten up. I didn't do that. What did I do? Hey, look at the note.
We didn't work program.
Huh. How silly of me. No, I'm still talking. Yep. That's what I did. I said, oh, this young man was given this opportunity not to have a record and to do what's right. And he doesn't even report to probation as directed. And he didn't even register for a drug screen. Let me just give him another slap on the wrist. Keep your status. I don't take you off the status. Still let you have the opportunity not to have a record. I charge you $100 for violating and don't even send you to direct jail. I gave you 3 days in the work program for messing that up. That wasn't enough. And that was in March of this year. And so here we are now in October, after 2 months after your probation should be done. Nothing. I gave at this wonderful lawyer you got, very persuasive. She told me when she thought you were not here, but you were out in the hall, she said, I believed in him. She goes, I don't know why he's not here, but I believed in him. He seemed like he was telling me the truth, and he's under HIDA, and I just wanted to fight the hardest I could for him. So I begged you to adjourn this case. You didn't have that coming, but she believed that you had documentation for many of these things. Not all, but many things, because that's what you told her. So then you come today with no documentation, but the one thing that you needed to do was an assessment. When you come in saying you're in mental health treatment, no assessment done. Well, I don't know why you didn't turn. If you went to treatment, they had to assess you before they just took you to treatment. Why didn't you turn in the assessment? I have no idea. Sir, this is horrible. This is just a blatant violation of the court's order. And it is a flagrant violation of my trust. I sit here days, over 20 years, and I've seen the run a gamut of young people, all different ages, men, women, black, white, anything in between, that I put on this status. And I know one thing I always say to them. Do you understand what HIDA is? I ask it. And then I won't even let the lawyers help you. I make you explain it to me. And what an opportunity it is and how it could, if you don't have it, what consequences could there be? People say, oh, I might not be able to get a job. Or I might not be able to go to school. The schools, among other institutions, they check backgrounds now. They go on social media. You better not even be posed with something that look like a weapon. You're not getting in. So I make sure my young people understand what's at stake. You just throw it away. I used to make parents come up here. And there was a day 20 years ago where the parents came anyway. They were here. Now, no parents. Nobody's parents even care what happens to them. They don't come with them. Maybe you don't even tell them anymore. It's horrible. And that's the root of the problem. If there's no parent coming, that means nobody looking out. Nobody's teaching you the right thing to do versus the wrong thing to do. And it really, really hurts to see young Black kids, especially. Because, when you got the history of the things that African American people have gone through and endured to get to where they are today, for me to even be sitting here in this job and others sitting in jobs similar, the first this, the first that, I'm the first one here, these are achievements that mean something. So to see people with opportunity throw it away. It's disheartening. And I've lived just long enough as a little kid to see segregation, to see just what that meant. To live in a little tiny town in Mississippi with people's, Black people over here, white people over here. I know the value of an education. Because my grandfather was principal of the colored school. So he taught all those kids that was a step away from slavery. They were sharecroppers. Seen the history. I ain't throw my opportunity away. I said, boy, it gotta be something I could do to change this. I'm going down to the restroom on the side of the road because you can't go in the bathroom. So it really bothers me to see people like you throw everything away that your ancestors died for. These were the strongest people that made it across the pond on the boat. A lot of people died. Your people made it just so you could turn out like this. Unbelievable. You just don't even get it. Because what does your life mean to you? Not much. So you could go work someplace and steal some stuff. That's why they died. That's why they marched for the equality, so you could get arrested just as equally as everybody else. When they was arresting you unfairly then, now you get arrested fairly. That's really what you're trying to live for. You stand on the shoulders of a bunch of strong people who endured a whole lot just to get out of those circumstances, to move north where they could have a little bit of a chance. People that couldn't read and write, but they knew that was the secret to freedom. Because knowledge is power, and power is freedom. So they taught each other how to do it, so they could get out of it, so that their little tiny babies that they running with could have a better future. And here you are, one of them little tiny babies don't care nothing about what they did. You were living in the now. Well, you know what? So what? It ain't affect me. I'm gonna do this. I'm gonna do that. This is what me and my boys doing. I'm still this. I'm gonna do that. I don't have to listen to the court. I don't have to do anything. So then you become one more statistic that everybody can point to and say, "Oh yeah, that little Black boy over there. Mm-hmm. He ain't nothing. Just a thief, a statistic, a casualty of the system." You don't have to be that. You chose that. These are your choices. Then you get somebody that's trying to help you, a prosecutor over there who has seen his personal share of hard times in his family, who understands, who sees something, who says, okay, that's what we're going to do. Then you get me. I care so much that it's going to worry me to death. I'd be dead caring about all the people that don't care about themselves. So I do what I got to do to try to help. Fashioning a sentence that's fair, helpfully you learn something. And many of my people do. They go to court, they learn something that they're thankful. So that's what we expect. But it's the ones like you can't anticipate it. Yeah, I don't understand why. I don't know what went wrong, but it did. Several different opportunities. You can't say you didn't get them. You had many opportunities here. And here we are. You got one of the most compassionate, empathetic lawyers that's going to be standing up there trying to argue when she don't hardly have nothing to argue, but she will stand up for you, and she did. I don't get it. So I can't rack my brain no more. It's something about this generation that I don't get. I will probably never understand. And I can't generalize and say every single person, but it's what I've seen normally. This is not abnormal. You know, not abnormal. I've seen them come in here and curse at me. It's just crazy. No respect for any kind of authority whatsoever. So the only thing you do is send them to jail for contempt. And this is the low level crimes. You had a higher level one and you got it reduced to a lower level. You had already graduated. And you just went straight to felonies. You had graduated to that. And we brought you back down here to lower level. See, we firmly believe that in lower level, we could maybe intervene some so that you don't graduate to higher level. Doesn't work for everybody, but for many, it can. And there's a few higher level people. One brush is all they need and they're done. And I've had a few higher level folks that just say, their record is pages. And they finally say, I'm tired. I'm like, well, what did you accomplish for the last 25, 30 years of your life? You've been in and out of jails, prison. They finally got tired. That's okay. As long as they see the light. It's not ever too late to change and focus on doing something right. Because see, this life right here, whether you know it or not, this is a pass-through. You weren't here before. Your spirit wasn't here. It came into this body to those parents you had, and it's going slowly out the other way. So nobody's going to be here forever. And the question is, what are you judged by? It's what did you do in that period that you were here? Me being a Christian, I know that you have to walk in the path of Christ. You got to do your best to do that. You got to repent. You got to pray. You got to read. Because you can fix anything while you're here and alive. Once you're gone, you can't do nothing. And ain't no mercy in hell. None. No God's down there. No mercy. So the things you did here, the evil you perpetrated, you're going to live that through eternity. That's the eternity. This isn't. And you never stop to think, how did I get here? Why am I here? And how long am I actually going to be here? These are hard questions. And all I know is you got a bad start here, Mr. Stewart, on some of this. And I firmly believe, and like I said, I'm a God-fearing woman. So I believe he acts through people sometimes to get his message of mercy and redemption out. Through the prosecutor, through that deal that you got, through your lawyer, through how hard she fought for you, through your judge, and how you were given opportunities. One day to explain all this. I'd start praying now while I'm still young and living to make a change. You don't want to end up in some perpetual situation that's not good. So, what is it, if anything, you want to say? Good. Hear my voice. You should hear it every day. And you should act accordingly. It's never too late. You got to change your ways, young man. You cannot be led by all this worldly stuff that's going on out here. The music, your friends, material things. You got to be your own man. You got to stand up for what's right. You got to do what's right. And the opportunity time for change was this case. You blew it. That ain't mean you still can't do it. Otherwise, you're going to be a statistic that I don't like. And who wants to feed into the stats? Because you're better than that. You know you're better than that. Just turn on the TV and you can hear all the stereotypes you want every day. It's all over the news. You really want to feed into that? Distinguish yourself. Be something different. Be somebody different. Do something that makes a difference in somebody's life. Change your own. Guide some of the young people that might be watching what you do. You 20, but there's 10-year-olds watching. They think all this stuff is great. They don't have a clue. Yeah, fast money, fast cars, music. All talking about demonic stuff. You listen to the words, it's terrible. So make your own change. Mr. Shockley, anything you wish to say?
I would just say, when Attorney Cameron Bell was on this case, he begged and pleaded me, for a reduction from the felony. I won't ever forget this case because this is one of the few cases where even the victim said, I don't want a reduction because he's not going to learn anything and we're just going to see him again. Because me and the victim had a long conversation where he said, I tried to take him underneath my wing, be a role model with him. And then we end up with a investment that I trusted your agent. I went against even what the victim wanted and gave him this resolution so he didn't become a felon and a statistic. Now we're here. The recommendation of probation is more than fair. Thank you.
I get a last word to you if you want it.
Yeah, I am not entirely certain about everything that's going on in Mr. Stewart's life. I just know that he's a young person. I know that he's a college student. I know that he not an excuse. It's just an explanation. I know that he has had a very challenging upbringing. I know that a lot of people have had a challenging upbringing. I know that he knows that he should have done better. He did not come in here today and say to me, oh, well, who cares? This isn't anything. He came in here with his head hung low, knowing, and he said, I messed up, didn't I? That was the first thing he said to me. And I said, yes. That's exactly what I said to him. I said, yes, this is not good. So I said to him, so he knows there is definitely at least, and that to me is a glimmer of hope because there is a part of him that can see this is not good. So I definitely agree with where Your Honor is coming from. Oftentimes I see so many young people and I just look and shake my head and weep for the future. But I will say that I do see a lot of potential in Mr. Stewart. So I certainly hope that he will learn from this. And the thing that is the most disheartening to me about this is the fact that he had the HIDA status. It's very difficult for young people. Well, for anybody right now, jobs are hard to come by, regardless of whether you have no criminal record or a criminal record. Your Honor knows that. And so that's the thing that is the most disheartening to me about this is that now, this is the situation that he's facing, and he knows that.
Well, it looks like we didn't adjudicate this matter. Those who want to plead guilty, We adjourned it without adjudication.
Oh, yeah, he knows. I mean, and I already discussed with him, the myriad of things that he did not, complete. And so he said, this person, he said, while I'm not fighting this, he knows that there are, things, I went over the litany of things that he did not complete. He knows that. And he told me he was gonna be pleading guilty to the violation. Am I correct, sir?
All right. So anybody force or threaten you? Been promised anything? You're pleading guilty here to the violation freely and voluntarily after speaking to your lawyer. So is it true that you had failed to report as directed to probation officer at least missing July 23rd and August 5th?
Yes.
That you failed to do your drug screens, like failed to register?
Your Honor, I am gonna indicate, and this is just, what is it, kind of splitting hairs, but I will indicate that he did initially register and he did go to some screens, but he stopped screening. So I understand that that's what she has on there, failed to register. I personally don't think that, it matters that much at this point because he said he stopped going to the screens because he couldn't afford it. I certainly don't think it's worth having a hearing because he is not disputing the fact to me that he didn't,
All right.
that he stopped screening.
Did you stop screening? How long ago?
I'd say like right around like kind of right before school started. So I say I stopped going. It was like the middle of like August.
So at least a couple months ago.
So did you also fail to provide proof of a mental health assessment
Yes.
and fail to go to the life skills class and the economic crime class? Okay. That's sufficient basis for the guilty plea, and I will accept the plea. I find that it is freely understand and voluntarily acted in line. Okay, well, not much more to be said. You just didn't do so well, Mrs. Stewart. So we're gonna go ahead and assess $100 violation costs. On both the files, I'm gonna revoke the Homes Youthful Training status so the convictions will enter. And 10 days in jail. Probation's terminated. While you're in there, think about everything that happened and why, and then make a plan as to how you're going to change everything. It's just enough time for you to figure it out, write it down on a legal pad, everything that's going wrong on one side, and point an arrow to the other side with the solutions as to what you need to do. Use this as an opportunity for growth, to do better in school, to get rid of the excess baggage of people who don't matter in your life, to try to strive to do better. Figure out what you want to do in life for your job and achieve that goal. And you can come back within several years and get these 2 misdemeanors expunged. So it's not the end of the world, just for a few years. Okay. That completes this matter. Mhm. Case number 25M00501ST, People State of Michigan versus Daniel Hardnett, that's spelled Danyell.
Workshop on behalf of the people. Good morning, Your Please court. Anthony J. Lewis, 43876, on behalf of Miss Hardnett, this to my left, Your Honor.
Oh, you know what?
We are here for sentencing.
Jim, that follower first.
We have reviewed the PSI. We have no addition, deletion, corrections to be made. Ms. Hardnett did have one inquiry
What is she getting?
of the 3-day impact weekend. I did confer with prosecutor. He informed me that it's something related to alcohol.
Mm-hmm.
That's as much as he could tell me.
Yeah, it's like an educational program. It's a weekend done like at a hotel or something,
Okay,
and you have to.
that was it, Judge. And she's satisfied with your explanation, and Judge, I need to leave as quickly as possible because I have a mandatory hearing at 12 noon.
Okay. Yeah. Well, is this report accurate? You said.
Yes, Judge.
Okay. The recommendation. Anything about that, Mr.
We
Lewis?
have no problem with the recommendation.
Okay.
Yeah.
Ms. Hartnett, anything you wish to say?
Yes, I want to know how much time will I have to pay that money off?
Through the course of probation. And even if you didn't make it then, we could still give you a payment plan.
Judge, just in case if the court did not hear her statement, she's unemployed at this time.
Mm-hmm.
Oh, Judge, she cannot work. She's disabled. So
Well, she got to figure something out. Will she get SSI? Well, she could pay something. She can do community service work.
Oh.
It doesn't have to be manual. There's places that just need somebody to sit down and answer the phone. Can you do something like that?
Judge, then I would ask the court to definitely mark the file in whichever way you normally do that. To let the probation department know that she will be working this off as much as she could as opposed to paying money.
Okay. Anything you wish to say, ma'am? All right. Well, it says here that prior to this offense, you were drinking a half a pint of liquor per occasion on the weekends. That's a whole lot. You said you were drinking because of personal stress and back pain. Yeah, not good reasons to be drinking like that.
Have a break. I have that whole pint. It's 2 shots for each bottle. 2 people.
Do you understand that a shot can get you over the legal limit for driving? Yes, ma'am. Yeah, it doesn't take a lot to get to 0.08. And in your case, it was a 0.165 blood alcohol level. So that's almost twice the legal limit. Okay. So it says here that you did go to some outpatient counseling after some charges that you had in 2013. Are you still in any type of counseling now or no?
Zoom calls.
Because I was concerned about some of the things that you went through early on in life. Are you getting support for that?
Yeah, but yeah.
Isn't-
That's not over.
Yeah, okay. Because that's important. All right. Well, it says here she scored consistent with outpatient treatment. And of course, we know she had a 0.16 bodily alcohol content. All right. And so the recommendation appears fair under these circumstances. It's for 15 months. And if you feel that you have done what you needed to do, you've benefited from your probation, you could ask to be released after half that time has elapsed. There's a form you could fill out, have probation send it to them, ask it for them, fill it out, and then give it back. And they will comment upon your compliance level. They'll send it to the prosecutor. If he doesn't have an objection, then he will say so. Then they'll send it to me. If I have no objection, then you could be released early after 7.5 months. Also, even if you haven't paid all the money, we could still put you on a payment plan and continue that, and you still wouldn't be on probation. That would just be a payment plan. All right. So, Mr. Shockley, anything from you?
Oh, yeah.
All right. So I think this is fair under the circumstances. She had a little pattern of drinking, and this was basically a first driving related offense with a 0.16. So some intervention, I believe, is necessary. So the court is going to follow the recommendation for 15 months of probation with $600 of probation oversight fees, fines and costs, $600. The jail time will be an alternative. There'll be 4 days credit for one with 3 days in the weekend impact weekend. I'll give her 1 day of community service, and if she wants to work more than that day, any extra, you'll get credit for $10 for every hour after that 1 day that you do of community service work. That can go towards your fines and costs. You can use a combination of payments and the extra work. There's probably at least $150 you'll have to pay because that's statutory costs and we can't waive that. Okay, no, you'll attend the crime victims impact panel. There will be outpatient substance abuse treatment. Of course, no alcohol or unprescribed drugs, and there will be testing. We'll do one AA meeting a week. That can be on Zoom or in person, whichever you prefer. No driving without a valid operator's license of some kind issued by Secretary of State. Do not frequent places where alcohol served or sold, primarily. So that means nightclubs, bars, parties. Know your friends. Don't go over their house and say, oh, I just had to punch it. I didn't know she spiked it. I hear that. You got to know. You got to ask. You can go to a restaurant and eat, but you just can't drink off the wine list. But you can go there. You're not working, so you don't have to maintain any employment due to your disability. $75 crime victims' rights fee, substance abuse assessment fee. That's $100. And then the emergency services reimbursement is $600. Counsel fee is $200. That's going to complete the sentence of the court. All right, it should go down to probation.
Let's bring up one clarification and it may be one and the same. And she picked up on it. I wasn't listening, but my mind is somewhere else. A drug assessment of 100 feet.
Substance abuse assessment fee. She had to do, yeah, she had to go down and be assessed by probation in order to get this report. And part of it was a substance abuse assessment.
That's fine. You have to come in and put it in.
And I was. Okay. All right, so she's all set. She'll check in with probation.
Thank you, Judge.
All right.
Judge, they need you to back me up with Judge Harkin. Wayne County.
Oh, okay. No problem. You can call him. Call.
I'll meet you down at probation. Jessica needs you to stamp for the collections on this.
Oh, yeah.
Stewart.
Yeah, I told her to catch it because I forgot to do. So this is going to be case number 25S00791FY. People of the state of Michigan versus Timothy Dansby. So what's your name? All right, Mr. Dansby. Good afternoon. Mr. Shockley, place your appearance on.
Traveling down the table.
All right, today is the date scheduled for a preliminary examination. This is on one count of retail fraud, first degree. People prepared to proceed.
Yes, Doctor.
All right, any preliminary matters?
Did you assent to the court rule confirm that the defendant still wishes to represent himself as this is a critical proceeding?
No, but do you still wish to assume he did?
Yeah, they just have.
He's been-
There.
He's just been asking all this time. Would you still want to represent yourself? You've been telling us all this time. Do you want to represent yourself?
I've been wanting to represent.
Okay, so you want to proceed today. By yourself without a lawyer, right?
Not before I let it be known that I still never received my full discovery.
Well, what haven't you received, sir?
I haven't had a chance to go over the videotape because one of the witnesses in the videotape that I know that when I was speaking to him and was saying, letting him know that, look, man, put this stuff back on here because I'm choosing not to buy it here and I'm going someplace else. So it wasn't like I was trying to steal nothing when I told the guy in particular I wanted to make sure that he's being available to be questioned.
I don't know who he's going to call. See, this isn't a trial. So this is just your probable cause hearing. So the prosecutor has a very low threshold burden of proof. He doesn't have to put on every witness, he said. He doesn't necessarily have to use the video. He might. And if you say the video means something else, that creates a question of fact that would go to trial for the trier fact to resolve. And of course, you get an opportunity to question about the video in depth at trial.
Also, I like to mention the fact that, you know what I'm saying, that it's been delayed because I don't know who these people been coming up there. I've been telling the court that I've been wanting to represent myself.
Well, you've been representing yourself since the last time.
Well, at the county jail, they said without the court allowing them to know that I was representing myself, there was certain information I couldn't get. They would not give me. Like the Michigan court rules of evidence. You know what I'm saying? For as far
I've never heard of the court having to tell the jail you're representing yourself. I've never heard of that.
The new technology, they tell the law library you can go. But now you can do everything over the computer.
Okay.
You got to do a request. In order for them to fulfill your request, they have certain criteria that you got to show ahead of time.
Well, sir, I don't know anything about what the jail's criteria is.
And also, I'd ask, for a standby lawyer.
But they don't do that.
Well, from my understanding from previous experience,
What
I'm from
what year was that?
federal circuit court and from other court.
Federal Circuit Court.
No, I know it has to be a circuit court. They have done.
This is the state system.
There has been opportunity to have standby lawyer for instances where they could confer certain information that the prosecutor might not want to give to me because he might feel he's better than me and stuff. Because he feels that if I come to the
Listen, Mr. Dansby. Okay.
he might allow me to resist.
No, of course you got. That's not true. You have a right to represent yourself and you do have a right to get discovery. But what you can't do is come in here on the day of the hearing claiming that, oh, now you want to stand by counsel. Okay, but I'm telling you.
I'm just saying it's always been standby counsel been set.
I don't know what your experience is. I just know what Michigan and I don't know when you got
information.
Okay, sir. The Michigan Indigent Defense Rules, they have a whole new program that's been started a few years ago. So we used to do standby counsel and anything like that. We used to do that all the time when the court was appointing. Now they have a whole system. They don't pay for that. They say if the defendant wants a lawyer, fine. But there's no, quote, standby lawyer in their view. So they don't pay for that. I didn't make that rule. I
couldn't verify it if I wanted to without the people in the jail who's running the law library information able to send me the information that I need, because without them having
what information sir, what information do you think you need just for a preliminary exam?
Your Honor.
No, I said for Michigan Indigent Defense appointment.
So then you said it used to give standby counsel.
I said we did before that system was created.
Well, I want the chance to update on the system, yeah.
Okay, but that has nothing to do with this
court rules of evidence.
Your Honor, I'm gonna, just so I can expedite this, and to satisfy the defendant. At the circuit court level, the circuit court has the budget and the ability and the staff to appoint a standby counsel once he gets up there. And once we finish this hearing, he may be up there and he can make that request then, and I'm sure that the circuit court will have no problem immediately assigning him an attorney to advise him as he represents himself. As far as the people are concerned, the court has been complied with. He's freely and voluntarily relinquished his right to an attorney May I call my first
So the
witness?
court, so, yeah, I like to also state that I still haven't received my discovery, and my date was proposed because of some guy who said he was my attorney. I did an extra 30 days, the extra 30 days.
Well, if you keep this up,
That's my attorney.
you
Why
gonna
wasn't my, why
you're gonna be here another 30 days. Do you want me to adjourn this case again?
No, I don't want to talk. I'm really actually having dismissed.
No,
For the simple fact that,
we're not doing that.
or ask for a personal bond because I've been have my cases adjourned on other people's. That,
Sir, you the one that asked for new lawyers or no lawyer.
I asked for any new lawyer because I never accepted the first. I have never signed for an appointment of an attorney from the very beginning, even at
Okay, sir. Well, we're gonna proceed with your preliminary examination without a lawyer. So you should be happy today that you don't have one. And then when you get to the circuit court, ask them to give you a lawyer. He just said they have a budget for that.
asked them to give me my discovery.
What discovery don't you have? What tape?
Your Honor, I'm gonna play the tape for him, today anyways. There's no right to it. There's not even a right to discovery before a preliminary exam, technically underneath the corporal. I mean, we deal with this all the time. So this is just an intermediate proceeding. It's not gonna affect anything. As you know, attorneys don't even ask questions a lot of the times during preliminary exams because it creates a function effect.
But they certainly don't call. They might ask questions, but they don't call witnesses.
Not in all situations. In all the preliminary exams, but this.
Okay. Have a seat, sir, unless you want to stand up for the whole hearing. Call your first witness.
People go to the stand wherever it's saying.
Okay, Mr. Shockley, are you ready?
I am ready.
Okay. Raise your right hand. Do solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth.
Yes, sir.
All right, thank you. Have a seat. And Mr. Shockley, whenever you're ready.
Yeah. Sir, when you are ready, will you please state and spell your name for the record?
Yes, it's Robert Sammons. R would be ERT. Last is SAMMONS.
Who is your employer?
Meyer.
What is your job title with Meyer?
Asset protection team lead.
Asset protection team lead.
Yes, sir.
And how long have you been employed in that capacity by Meyer?
Since January of 2025.
Did you receive any specialized training to have that title or that role?
Yes.
And what do you do? What kind of training?
So it's a multitude. So over years, Wicklander certified, and then different courses in asset protection and policy related, that kind of stuff.
Are those courses designed to help you detect retail frauds or patterns of retail frauds?
Yes.
Were you employed in that capacity on July 26, 2025 around 5:30 p.m.?
Yes, sir.
And so employed, do you work at a specific Meijer store or multiple stores?
I'm assigned to the one in Southfield.
Is that located at 28800 Telegraph Road,
Yes.
City of Southfield,
Yes.
County of Oakland?
Yes.
On that date, around that time, did you identify a retail theft in progress?
Yes.
And how did you identify that?
In this particular case, it was just rapid selections of this similar merchandise.
What do you mean rapid selections?
So one of the indicators of theft is grabbing merchandise without looking at price or without appearing to look at price, size, that kind of thing.
And how did you see this occurring?
On the floor.
Were you physically on the floor or were you watching cameras?
Sorry, I was physically on the floor.
Did you follow this individual?
I did.
As he was selecting items?
Correct.
Do you see that individual you're following presently in the courtroom?
I do.
Will you please point and identify an article of clothing he is wearing?
It's the over to my left, and he's wearing like a blue shirt with a white t-shirt.
Your Honor, may the record reflect the proper identification of the defendant?
Yes, so ordered.
Upon following this individual, that at one point he come to the point of sale?
He did.
Was that before, at any point did he try to walk out before coming to this point of sale?
No.
Did he have a cart or was he concealing these items on his person?
It was a carton.
Was that cart full?
Yes.
Upon him going to the point of sale, what did you, just so we put, you were at the point of sale when he got there?
I was, yes.
And what did you see him do at that point?
He went up to a cashier, and myself and asked for the bathrooms.
Was that before or after the cash register?
That was it's kind of at the same time. It's like at a, it's like a giant area where there's like self checkouts.
Are these self checkouts?
Yes,
Is there a long looping line to the self checkout?
correct.
Okay. Do you still have the cart with him?
He did. So he left the cart, actually by me, and then he went to the restroom.
And what did he do? Did he come out of the restroom?
He did.
What did he do upon coming out of the restroom?
He grabbed the cart and proceeded towards the opposite side of the store, which would be the grocery side.
And what did he do upon getting to the grocery side?
He pushed the cart out, exiting the store without offering anything.
When you say he pushed the cart out, is there a double door vestibule to Meyer?
Yes.
Did he enter
what?
a double door vestibule?
Vegetable.
That's the whole.
Oh,
Not
vestibule.
Yeah.
Okay, got it. Okay, go ahead.
Yes. So it's basically what it is. It's an opening with EAS towers, and then he pushed past those EAS towers.
What is the EAS tower?
Electronic article surveillance that detects the tags, that the merchandise protection tags on merchandise. The thing that beeps when you guess it.
Did they beep?
None of these had tags. So no.
Okay. Did you stop him at that point?
Yeah.
Did he say anything to you upon stopping him?
He said, I can't recall exactly what he said.
But he did say something?
He did.
Okay. And what did he do upon you confronting him?
He walked past me and then went out the doors going to the on the grocery side in the parking lot.
Did he abandon his car or did he try to take his car with him?
He abandoned it.
Did you retrieve his cart?
I did.
Were you able to scan the items that were contained within the cart?
Yes.
Upon scanning these items, was a receipt produced?
It was.
Yeah, may I approach the witness?
Yes.
People pose exhibit 1. So I take a second look at what I just handed you. What is that?
It's a receipt from there.
And did it fairly accurately pick the items you scanned from the cart?
Yes.
Has that receipt been edited in any way to your knowledge?
No.
People are going to admit people's exhibit 1.
Show it to this. Him. Okay, sir, that is People's Proposed Exhibit 1. Hello? Well, he's offering it. Is there an objection? Okay, no objection heard, admitted.
Commissioner, approach and publish.
Yes.
Thank you. Sir, there's line that says cameras.
We did.
And were those cameras working operational on that day?
They were.
And did upon him leaving the store, did you contact law enforcement? Did law enforcement come to your location?
They called him like in the they went towards 12 mile, made a right. I'm sorry, I don't know if it's east or west. Made a right and they caught it right there. And then they came.
Okay, so to answer my question, law enforcement did come to your location?
Yes.
Upon them coming to your location, did you show them video for this then?
Yes.
Previously to you taking the stand, did I show you what's on the splash drive?
Yes.
Is what's on the splash drive the videos from Myra that day?
Yes.
People moved to miss people's proposed exhibit 2.
Sir, any objection?
People's proposed exhibit 2 is the camera footage from Myra, correct?
Yes.
And that's the same footage we turned over to police? Yes. People moved on that.
I'll object to the fact, John, I haven't had a chance to go over, take previous to the examination. You know what I'm saying? I'd like to state for the record that being able to go over there would be part of my discovery. And since the prosecutor said, I guess upon his word, I guess he's making precedence that you don't have to give.
But why don't we do this, sir? Let's play the video without admitting it so you can watch it. Then if you have an objection, you can lodge your objection at that time.
Step out.
Who is he?
What?
Why should he step out? He's already seen it.
But he ain't seen it when I'm looking at it. He might be making them different.
No, we're not. He doesn't have to step out. We're going to show you the video. Go ahead, sir. There's your video.
I'm straight.
You said you haven't.
Video. I was there.
Well, you said you wanted to see the video.
I was present, John, when.
Sir, either one way or the other. Are you objecting to the video? Yes or no?
I don't know if it's the whole video or not.
Okay. So
Run the video.
go ahead and play it.
Sir, if you would turn around and look at the screen, is this one of the videos you provided to? You can stand.
Sorry.
Yeah.
So you run the video for him or for me?
We're showing it to you, but he's gonna
tell him to turn around.
identify what it is.
I mean,
Then
if it's my time for me to watch the video, then I watch the video. When it's his time to ask him for questions, then he can watch the video.
let's have him identify what it is he's showing. Let's at least do that. Okay, let's do that. Go ahead, Ms. Shapley.
Sir, is this a video you turned over to Southfield Police?
Yes.
Is that actually you in the video?
Yeah, it's being go on right now.
Okay.
All right, no more questions. Just let him watch it.
Okay, this is at the this is gross exit view. This is at the 17 hour, 53 minute mark. So is that you walking out with the
No questions. Just let him watch it first.
well, that's out of that one. That's him leaving the store. You want the store.
I can see what it is. Just let him watch it. Then we'll come back and you can ask questions once he objects or I admit it or whatever, because I'm not admitting it yet.
Can we play the next video then? This video is labeled GM SEO overview.
Okay.
To this 17 hour, 47 minute mark.
I can't see you.
Okay. Well, why don't you walk up there closer?
I'm stopping the video at 17 hour, 49 minute, 12 seconds.
Okay. Is that it?
Yes.
All right, sir. Head back to your seat. So that's the video that he seeks to admit. Do you have an objection?
Yeah.
What is that?
Complete video of the incident that happened. Because At this junction right there, I was going to the bathroom and I did not go past.
Okay, but sir, that's an argument. You can make an argument later. The question is this the video that purportedly was taken by Meyer cameras and turned in by this witness to the prosecutor's office? He said that's what it is. Now you can question the validity of it, the length of it, how long it was, but doesn't affect the admissibility of it. So, okay. So it's submitted. So you want to ask him some questions now, Mr. Shacklin?
Yes, Donna.
Go ahead.
This is other two, just for the record. Sir,
So you want to stand up and look again?
Oh, no.
He's gonna take you.
Oh, you want me to
I'm gonna go back.
He's gonna go back to that first video.
Yeah. And just so we're clear, so the time and date on that video is correct, right?
Yes.
And I'm gonna play it now. Grocery exit view at the 17-hour 52-minute mark.
I got look. I'm gonna ask him to play that back.
So is that you confronting the defendant?
Yes.
When he was walking onto the exit, is that after he abandoned his car?
It's like this part right here, you're talking. Yes.
Yeah.
Where's the card
You see the lady,
with the pink hat?
no, man, the one with like the dark pants and the black shirt right there.
Meyer outfit?
Yes, ma'am. The cart is right there, just in front.
I'll run it back.
That's the part I'm trying to see. You don't mind.
Yeah, go ahead. Mr. Shah. Oh.
At that point, he walked up with the car, right?
Yes.
And one of your associates takes it away from him?
Correct.
And then you confront him.
Oh, wait a minute. Oh, you said somebody took the card away from, where's that at? You should have shown me that. You think,
Okay.
sir,
Sir,
Yeah.
no, you don't ask the prosecutor questions. You have to ask the witness questions.
I don't have access to go over the ground and take myself, yeah, because I haven't been allowed my copy of the tape or the electronic.
Well, it's not your time to ask the questions yet. You get a chance to.
I don't have a copy of the tape to go.
Sir,
over
you
that.
don't need it. You watched it.
Well, I'm watching it. I'm trying to verify what's going on.
Okay, but you're not doing it right. You have to wait till he asks the witness questions,
Okay.
and then you'll get a chance to ask the witness questions too.
Sir,
I know that.
you see the person in the middle of that video that looks like has got a white stripe at the bottom of his leg?
Yes, sir.
Okay. Is that the person you identified as the defendant?
Yes, sir.
Okay. That card he appears to be holding it in his hand. Is that the card you took the items out and then scanned to create that receipt, which was People's Exhibit 1?
Yes, sir.
Okay. You are good.
Where's the card?
It's right there at the entrance by that lady in the blue shirt and pants. She's holding it.
How did you get there?
You were,
I take it.
sir, if you watch the video, it shows you, he identified you pushing the cart. And when it got to that part, they stopped you
Okay.
and took the cart.
Now they took the car, but there was an individual. It was a young black male.
Okay, sir.
Hold on, y'all.
But just, you're not testifying.
It was a young. I'm not testifying.
Yes, you are. You're trying to tell us your story, and this
I'm
is
trying
not.
to tell you that the tape. This is not the full tape.
Okay, this is not the time.
This is not the full tape.
Okay, sir.
This is not the full tape. How can you show half of the tape and then the signature instead of showing the whole tape? From the times that I left, from the times that I left The black car, the where I was paying for the tape and walked in there, it's the whole step was missed. So where is the step is missing the property?
You'll get a chance to ask him those questions.
Well, how am I gonna show him if I can't show my?
You'll get a chance to ask the witness that question.
I want to be able to see on.
He's the one who says he made the tape and turned it in. He's the one who would know if there's a section missing or how he copied it.
I should wait for my court for that.
Yes.
Come on back.
Mr. Shockley, are you done with this particular tape?
Yeah.
Could you do me a favor? Roll it back to the very beginning of this, where there's people coming out of that door on the left. I'm going to tell you when to stop something. I just want to see something.
Once you gone?
Yeah, keep going. Just a bit, okay. Okay, play it.
Did he stop with that? Take that with property? Did he stop to take that? With the shop?
Yeah.
When the defendant was pushing that,
Sir, no.
Okay, all right.
Not your turn.
Okay. All right, well, you have the word, okay.
You gotta play it again when it's your turn.
Okay.
I bought the front of Lisa's store. Correct. Yes.
Okay. Now, are you gonna have to play that overhead camera view?
If you would like me to.
I don't know what that was. So if you need it, you can play it. It's part of it.
That's what they do.
That was 17 hours 47 minutes. Sir, pause the video for a second. Do you see yourself in the bottom left corner of that video? Too small.
First of all, what area of the store is this video depicting?
Your Honor, this is in the GM side, so this would be the north side of the store.
Okay. So, service desk to the left,
Yes, ma'am. So if
and that's where's the out? Are the doors depicted in this? No.
can I go closer to see
Yeah.
if it's like easier? So when you went to the bathroom, it was right this way.
Okay.
Okay. And I went towards the door, is he takes the cart here and then goes this way down that long aisle. And then it goes into the grocery, which you saw.
Okay. So that's what this is depicting. And so that's like the open area where you come in. That's no cash registers right there.
Oh, no, I'm sorry.
Is that them right there? Walking right up there.
So this is your entrance right here.
Stop right up there at the top. Is that him?
You'll see him.
Right there. Is that him?
Don't allow to ask any questions yet. Yeah.
Not yet.
You gotta wait till it's time to cross examine. This is direct exam.
Okay. Well,
Why did you decide to just stand there?
Because he's in the bathroom and that was his part right there.
You just watched it start?
Yeah, so at that point, that's all I cared about.
Are you speeding up?
Yeah.
So a good couple minutes.
what is the time in it?
It doesn't show on the full screen. Dude. What the defendant right there going to get his card?
Yes, sir.
What again? I go to dedicated all the pussy. Can we see the signs?
Mr. Shaka, can you show him the timer?
The time.
This is that point. The time play frame is 17 hours, 52 minutes. The grocery exit view, when I started playing that video, which is the last video we saw, was starting at 17 hours, 53 minutes. Is it fair to say that you then took his car to that grocery exit?
Yes.
Okay, and that's where you stopped him?
Correct.
I don't know if, what was you remember what the value were? I've never seen.
Exhibit number 1?
Yeah.
Says $39.99. Oh, I'm sorry, $207.12.
I believe it's just over 2 months.
Yeah, that was the one item I was looking at. $207.12.
You can sit down, yes.
Okay, are you finished?
I'm done.
Okay, sir. Cross examination now.
Okay, I'm gonna need to know. I do.
He can play it.
Okay, now,
What do you want him to play?
if this document right here, this is chocolate,
Yeah.
salmon,
Yes.
this is salmon. If this point right here, when you spin the vessel, the self-pay machines, or walking towards the cash register where it would be taken in, and you went that way, at which point did you start walking behind? Can you run the tape? At which point was you walking behind as you finished? letting him know that you'd already called the police.
I don't understand. I'm sorry, so I really don't understand your question.
Okay, at one point when he put that out there, put him. Yeah. And you came behind and said, I'm gonna come to my office, I already called the police.
Yes, sir.
Okay, was that before or after he got called to a rescue?
That was after the accident.
That was after the accident was here,
No, sir. It was,
after the accident of the store.
yes, sir. After the accident.
So when he was walking this way, can you show the tape? Can you show the tape? He was the prosecutor, but pushing the car.
You want to see this video that's permanently
I
on?
want to see the video of the park. It was all on one camera. Then you zoom into the park where the defendant is pushing the car. Going towards the other end.
This is the video you want to see, sir, correct?
Yeah, he wants to see where he's pushing the cart going towards the other side of the store towards the groceries. If you can zoom in on it. I don't know if you can.
You could see it better on the.
Now show us, witness, where he is in this view right here.
I go.
Yeah, going up there.
Right.
That's the cart and that's him. Okay. So what was he doing at the scanner machine there? Did he scan anything?
Yes, ma'am. He scanned one item and then put that same item back in his cart, never offered payment.
Okay.
I have a question for you, Mr. Skinner. Did you check that scanner? After he left?
I did.
And what did it say?
And one item up there.
And what was the price of that item?
Don't recall.
Because it didn't work.
And so point to him there in that shot. He way down there
Yes, ma'am. He split it down.
where the pointer is.
Yes. ma'am.
And this when you approach him?
No, sir.
And who was the other individual, the black young male that was on?
So you'd have to show me which one. There was a couple over there.
He kicked them very tight. Time on. So at that point, when you spoke to the defendant, or spoke to the, was there anybody else there that had a conversation?
I mean, I'm sure those.
No, was there another employee there? Conversation.
Like when you and I were talking.
When you approached. Because I ain't seen you head out the door.
Yes, sir. So there's 3 employees there total. So myself, another employee, and then another employee. And then when you and I were talking, it's just
Hold on. Where is the young male? It was a black guy right there.
there's a
Right there. Now. You say you come right here, right?
yes, sir.
Can you show But you go back to the top. Okay. Right here, right here. Can you go back to this part up here? Well, not down another time. This part right here. Because it appears to be stop moving. Yeah, right here. Now can you run that, showing that part right there? Next, stop. What's this right here?
That's the time.
What's this right here?
Huh?
So why is it not in this ticket? Why is this moving faster than that?
It's you see so that's the defaulting. Those three that goes to those cycles.
All the thing is going to be really tricky. I'm talking about this time here and this time here. Why is this, 17 minus 12 was 5? 17 minus 12.
Yeah, it's
I know, no, 17 minus 12 was time. Here's the time. Okay, can you go back? Let's talk about 3 minutes. But what I'm trying to figure out here, Mr. Is how
Mr. Attorney, you talk to witness?
to the witness, yeah. I'm wondering.
The witness is Mr. Salmons.
Why I keep saying shot?
That's a prosecutor.
You know what I mean?
Yeah, I appreciate
yeah,
how,
I
I mean, I'll take it.
Well, what junction did you say would you like to come to the office with me?
It would be, it's okay to go up. Yeah.
You can always step up and point.
It would be right here, sir. Like, right, see those towers, just past those towers right there.
And you're finna go past those towers.
Yes,
And they beat.
no, sir.
Why not?
Those towers are what they're called is electronic article surveillance. What they detect is merchandise protection that's on products. Not all products have that merchandise protection. So it'll only go off if one of those products that has merchandise protection.
Okay, so hold on, wait a minute. Stop, can you go back one more time to talk to you about another minute? Because what happened to the okay, go back. Okay. So hold on, go forward. I'm trying to see which tickets, which with this with. Okay, that's her stuff. He's going in with her stuff. He's coming out with his, right?
Yes, sir.
So his stuff never went past him.
It did. It went right to the towers.
So what happened to where's this Carter?
That would be the part that the defendant was pushing, sir.
So it never went past him.
It did. You have to see it. You'll be able to see it, sir.
Okay. Okay, but you say stop. You stop right there. No. We not gonna phase. Okay, right, okay. This individual I need to see right. Who is this individual right here?
That's another employee of.
Yeah, what's his name?
I don't know the last name. It's for this kid.
Is he part of your team?
My team helped an employee of mine.
Not an employee yours?
So he doesn't work under me. No, he's just an employee of mine, but he's not on like my specific team.
So was you close enough with the conversation was held between him and the defendant?
Your Honor, if the defendant's done with the video, I would ask him to go back to his table.
Are you done, sir?
No. I'm only done with the video because I'm trying to figure out, Mr.
Sentence.
How did you beat the defendant in the buck?
Yeah. That's so I was following the defendant along the back aisle, where I could keep it where I could watch while I'm walking.
Okay. So at which point did you, when you was walking behind him, when you was walking behind him, was you out the store?
I was never behind. I was always to the side.
No further question. Just one. Now, I do like to ask you a question. Are you saying that you know that you couldn't pick it up items without checking the price?
Appeared.
It appears to be. So this is how you profile the individual who was coming in.
No, so we don't profile. What we look for is behaviors. So,
Okay, profile behavior basically kind of like it's the same. And also, when you went to the scanning machine, you said did you go back and check the thing on the scanning machine? See the scanning?
I didn't need to. I was at the where I was. I could view every scanner and I could see as it goes.
So you're seeing the one thing get scanned,
Correct.
and you're seeing the machine activated. Or do you know if it actually scanned?
I don't know what you mean by activate. I apologize.
When you go to the self-care key and try to scan it,
Yes.
it's ready.
Yeah, it'll beep and then something.
Right. Did you hear it beep?
There's lots. There's like
No
stuff.
further questions. Because it wasn't working. All right, no further questions.
Mr. Shockley, anything else?
No.
Sir, thank you so much. You may step down. Any other witnesses for the people? Thank you. All right, sir. Do you have any witnesses? Typically, the defense does not call witnesses at a preliminary exam. But do you have any witnesses?
Like I said,
Do you have any witnesses?
I haven't had a chance with the witness that I would have liked to have.
Okay, but you don't.
I wouldn't get a chance because I never got a chance.
Sir, you still got a chance at trial to call a witness. This is not a trial. All you're going to do is create a question of fact. Okay, wait, we're not at the argument. Stop. Mr. Shockley is going to make his motion. Go ahead, Mr. Shockley.
By the defendant over as charged, as you know, this is retail fraud in the first degree. It's enhanced from a second to a first. Dollar amount is over $200. The video of shows in the testimony, Mr. Salmon shows that he attempted to leave the store without making any ability or offer to pay for those items. Accordingly, we're going to say bound over as charged. Thank you.
Yeah. What do you want to say by way of argument now, sir?
I'd like to say, Your Honor, that it's been such a long time, I never had a chance to get the tape. You know what I'm saying? And I also like to state.
You went over that tape ad nauseum today, sir.
Like that tape, the prosecutor didn't have to take so long, but that's not exact. That tape doesn't exactly show what happened. But that individual was walking behind him. I don't know how he did that to tape. That's why I was looking for the time. And also, I like, again, just for the matter of the question that impropriety on the way the examination ran for the simple fact is days and the time that it took, even though the prosecutors did show his willingness to show the tape, did not give me a chance to go over the tape. On in this, I haven't had a chance to even call, and I still to this joint don't know the witness name of the individual that.
Sir, you got plenty of time to find the witness and call them for trial. This is not a trial.
I'm gonna do it, Your Honor, if I can't get the paperwork.
What paperwork?
I can't get the discovery motion for discovery.
You got a folder full of paperwork. A police report, right?
I'm talking about, Your Honor, the paperwork in order to get the discovery.
No, I don't know what paperwork you're talking about.
Rest of the discovery, the motion to be able to write the motion for the discovery.
No.
The Michigan court rules to determine that the Michigan, or you don't know the Michigan court rules to determine that the prosecutor must.
No, you know what? I have no idea even what you're talking about at this point. You got the police report, which gives you all the information.
And for the last,
I'm not quit talking.
I like to put on record.
I'm just gonna stop talking. You can take over this whole courtroom. Go ahead, and you got about 3 minutes to do it.
All right. For the last statement, I like what state for the courtroom. Still, that the court never actually showed its authority to trial the individual, because I don't know if this prosecutor in the court even have license to practice law.
Okay, no, we're not going down that road. Excuse me. Listen.
I don't have, hold on, I got a constitutional right.
Let me tell you something. If
Stop talking to
if you don't stop when I tell you to stop, I'm gonna take you out of here. We're not getting into whether somebody has a license to practice law. You are to contain.
It's a legitimate argument.
Listen. You're to contain your argument to the facts
And it's here's the fact. The fact
on this case.
from
This on the record.
the Bar Association, it said that it is not a licensed agent. So if you got a bar practitioner without a license, which the Constitution of the United States and the state.
Sir, I'm not going to listen to that.
No state, no city, no township, municipality can think of all contrary to the.
Nope.
The highest law of the land. Now, for that to be placed on the record.
It's placed on it. Now, you're done. The defendant is charged with a retail fraud. All the elements were met in this matter for retail fraud first degree. The testimony clearly established that the defendant took property of the store that was offered for sale. It showed by way of testimony that he took property off the shelf in a random manner. The testimony was all the same things without looking really at the prices or the tags, it seemed like. That he moved the property, he put it in a basket and walked all around the store from one side to the other. Third, he intended to steal. That's a question of fact as to whether or not he intended to permanently deprive the store without the store's consent. However, it was clear from the video shown that he walked from one entrance to the other entrance without paying for anything and was attempting to push his cart through the entrance when he was stopped by loss prevention from doing so. That's the question of fact, why he was doing it with the intent to permanently deprive or not. And this really happened inside the store while it was open to the public and without the consent of Meyer. The items were tallied up by loss prevention and came to $207.12. So clearly, that's enough to satisfy the court that the retail fraud did occur. And of course, there was an allegation that he apparently had a prior conviction, April 17, 1989. For retail fraud first degree in the Sixth Circuit Court. So that's the sentencing issue, and that's enough to bind it over on the first degree and continue to bond. Mr. Shockley, here is your exhibit back. His bond is continued. Make sure you get a license to practice law, please.
And don't present doctored video. Video's been doctored and altered. Oh my God.